Welcome back to the Law and Crime Network. My name is Stephanie L. Willis, and I'll be with you for the rest of the afternoon. You just saw what can be described as an incredible clip from a father who lunged at Larry Nassar during the hearing today out in Eaton County. We do know that this hearing today is before a judge in Eaton County, and it's Judge Cunningham. We are not before Judge Aquilina anymore, but we are before Judge Cunningham, and we expect to hear approximately 56 victims today or throughout this hearing. We expect it to go throughout Tuesday. We don't know if there will be more, but we do know that we have the wonderful Bob Bianchi with us today. Bob, how are you today?
I'm doing great. Thanks for having me on.
Oh, no, it's our pleasure. And how are you after watching this clip? I mean, this is something that we tend to, I don't want to say we tend to see a lot, but we know that there are a lot of emotions in the courtroom, especially when dealing with a case like this. What have been your experiences, if any, with this kind of a situation?
You know, I've seen a couple of violent experiences in my career in a courtroom, but I have to be honest with you, when I saw this and people were like, you got to watch this on video, because I wasn't watching it at the time, it gave me goosebumps. It's just really, you can understand the emotion. The victims' families many times want to do whatever they can to get their hands on that defendant, and very infrequently does it happen. But when it does, it's usually not as dramatic as this. Usually they're able to put it under control. The cops did a great job in controlling it, using the proper amount of force. But wow, I mean, you can think of what a father going through something like this, you know. And you know what I also thought about, Stephanie? You know, one can only imagine what he's going to be facing in jail, you know, when he gets there, because he will not be looked upon kindly. So I think what the father was attempting to achieve in the courtroom, I'm not saying it's right, but I think will be exacted often in the jail scenario. Well,
you touched on something that I think is important. It's not right, but we have a situation in which there is an individual, this defendant, Larry Nassar, who has pled guilty to these charges. And so we have a situation now where we have children who were being affected by what he was doing. And as a result, it's normal that we would have these kind of emotions in the courtroom. But what does the judge or the prosecution do now?
Great question. So, I mean, obviously the judge has to maintain order, right? And the officers that are in the courtroom, because he is a ward of the state, are legally responsible for his health, safety, and welfare. So they need to maintain order in that courtroom. Now, it's an interesting question that you ask, because having been the head prosecutor of an agency where there were issues that happened in courts, inside the courtroom, sometimes we were asked, and I ultimately had to make the call, would this person be prosecuted for attempted assault or assault if in fact he got to somebody, or resisting arrest with the police officers. And there's where we get into that big, huge prosecutorial discretion issue that we as now defense lawyers, or when we're out in a real courtroom, we deal with all the time. Some prosecutors will follow the letter of the law and say, well, that was not correct that he did that, and therefore we're going to go forward with a prosecution. And then you have other people, which would be me, that would sit there and say, listen, I get why he's emotional. I'm not saying it was right, but there's no need to deter this guy. You can understand the circumstances. Nobody was harmed. I'm not going to prosecute the guy. So the judge, of course, can then make a decision on her end as to whether or not she wants to hold him in contempt of court, which I seriously doubt she's going to do.
I highly doubt that as well. But one thing, and it may be a tricky question that I'm going to ask, but if something were to happen, let's say Larry Nassar was injured as a result of this. You said that at this point he is a ward of the state, right? So would there be any liability on behalf of the state if something happened to him?
Well, so you're talking about a civil case, right?
Yes,
so
absolutely.
Now, in a civil rights context, and usually we have federal and state laws, and you are a ward of the state, you're in their custody, therefore they're supposed to maintain the health, safety, and welfare because the person no longer has their freedom. So the answer to your question very directly is yes, they would be responsible for not having maintained the proper amount of security to ensure that something like that didn't happen. Whether it would be a good lawsuit, you know as well as I do, you may be liable technically under the law, and every civil suit has two components. You have, are you liable, and then what's the case worth? So would they be liable? Yes. But what would a jury come back for a guy that went and attacked Larry Nassar if the government didn't properly protect him? I'd say it would be the big goose egg, or in Italian we say senza niente, nothing. They give him nothing. So they could technically do it, but it'd be a bad case.
I have to agree with you. Now we have Larry Nassar coming back into the courtroom. This is the third time that he's being sentenced. Well, that he will eventually be sentenced. This is the second time that we're having these victim impact statements. And so when we're looking at this, what do you think as a defense attorney now? What's going through your mind?
why did I get involved with this case?
Right.
What's going through my mind? I've never seen in all my years of the 30 years of doing criminal prosecution and defense work, the breadth or scope of the number of victims, the qualitative goosebump kind of like really horrible repetitive acts like this guy. I've never seen victim impact testimony, even in death penalty cases, that has been so significant as what we have seen here, the harm and carnage that this gentleman, if you want to call him that, had created. So as a defense lawyer, I would just be telling him to basically do what he's doing. Just shut up. Don't make any faces. Don't roll your eyes. This is their right to be able to do this, and you're going to have to deal with it. It's all part of the package. And then I just want to, as a defense lawyer, you ask me what I want to do is I go home and take a shower.
Well, I asked you this because we know that his defense attorney, Shannon Smith, made a public statement, apparently without his knowledge, stating that she doesn't believe that all of the victims were actually assaulted by Larry Nassar. Now, is this, as a defense attorney, is this something that you think was a good idea on her part?
First of all, no, I don't think it's a good idea.
Right.
I mean, even if it were, in fact, partially true, the fact is he has done this to a number of people from a credible point of view. He has pled guilty to having done it to a number of people. And you know not to tease the beast. It's bad enough about what's going on in there. To sit there and start calling some of these people who I believe to be victims non-victims is only exacerbating the problem for him and re-victimizing these girls.
Right.
I mean, so I thought it was very unartful, although I think I read somewhere where Nassar kind of broke his silence a little bit and said, listen, I am not contesting any of these things. My lawyer had no right to make that statement, and that was a smart move.
Yeah, I think that was a little bit of a misjudgment, not a little bit, a misjudgment on her part to make that statement. She stated more so, it may be more so of a psychological, I guess, issue, per her claims, that maybe some of the victims, they provided their impact statements and they didn't have the same situations that a lot of the other victims did in regards to you know, the insertion of the finger into the vagina and what so have you. But we often see in cases that there are some times where witnesses or victims do tell stories that may or may not be true. Do you think that this is something that is possible in this kind of a situation, or no?
Well, you're going to ask a lawyer a question of what's possible, and I will answer in the way that we would, right? Everything's possible. But it's been my experience, especially as a prosecutor for many years, that people, women in particular, who are victims of sexual assault do not wish to, in fact, come forward and expose that. There's a lot of fear, and then there's a lot of sometimes women thinking like, well, maybe I caused this to happen, and there's a lot, you know, they don't want to be humiliated and embarrassed. So I would find it very difficult to believe that a number of people just decided to jump on in to have a little fun, because it's not fun. So the publicity that you get, the fact that everybody thinks, you know, or knows that you were a victim of sexual assault, still has some sort of stigma attached to it in society. So I find it very incredible in my mind that a number of women or girls that are now women came forward simply to jump on the bandwagon. I don't buy that. Yeah,
as a matter of fact, I think one of the individuals who provided her survivor impact statement, we'll say, she stated that some of her friends didn't even want to come forward because they didn't believe that they had been assaulted enough for them to provide an impact statement. And so this kind of goes back to the whole Me Too movement. And so I'm just thinking, like, how can someone essentially outright say something like that? I think that she was teetering kind of a fine line.
Yeah, so we get back to the prosecution piece a lot of times. I've literally sat down with women who were victims of domestic abuse, especially when they were children, that come forward. And before you even jump into the piece about how the prosecution's going to go and how we're going to go about proving our case, I always at least used to sit down and talk to them about the value of what it was that they were doing, because there's, again, remorse. There's like, I really wasn't that sexually assaulted, as you put it. Some blame themselves for having put themselves in that scenario. And so you try to diffuse all of that, and you try to explain to them the importance to be strong, Let's get you the counseling that you need, and let's just put this guy away, because if he did it to you, he may do it to somebody else. But I think before you even, I found some prosecutors I've witnessed in my career that kind of go in there very matter of fact and sit down and tell me about every aspect of this personal scenario. What did he do? Where did he stick this, that, the other thing? And it's kind of jarring, especially to relive those scenarios. So you got to be very, very careful about how you bring a victim along in those scenarios, so that you don't re-traumatize them, and they feel empowered about moving forward and testifying and doing what we would call the right thing. Right.
In your experience as a prosecutor, when an individual is providing their impact statement during this type of a hearing, is it more so of a power move, I guess, on their behalf? Are they able, have you, I guess, received feedback that they're able to essentially move on once they've done that, or not?
Some, you know, it's funny you should say this, and I'm writing a book right now, and there's a section dedicated towards what I have looked at, I guess, from a philosophical point of view, about how some people have been involved in some of the most traumatically horrible things. And yet they're able to become resilient and move forward, and how some, under the similar circumstances, go down that dark, you know, hole, and they can't ever get themselves back out, and they redefine everything in their life based upon that. Now, and understandably, I'm not faulting that, but excuse me, I always wondered in my mind, what is it about the person that makes one a resilient person and uses the trauma and pain to move forward in a positive way, even though they'll never forget it, and one who doesn't? So I think that there is a certain cathartic or you know, a release for them to get up and to have their day in court. When I started practicing law, the victims were never even consulted about what the plea bargains would be. They were never told when the sentencings were, and they never had an opportunity, except for a death penalty case, to give a victim impact statement. How far we've come in 30 years. Very far, very far. I have to agree with you. And, you know, there's also more so of the victim impact witness individuals who are there as a support system for these survivors. And we saw, even throughout the last hearing with Judge Aquilina, how supportive a lot of the individuals from the prosecutor's office were for the surviving victims. So was that something that you had in your office as well? Oh my gosh, yeah, the true heroes of my office. I mean, we had great prosecutors' offices. A lot of your viewers may not know are. Oh, Bob, sorry, I'm going to have to cut you off real quick. We'll get right back to it, but we're going to head back into the Nassar courtroom. Mr. Nassar, or Larry Nassar, excuse me, is being brought back into the courtroom, so we don't want you to miss a thing. So take a look. We are currently back in the Larry Nassar case. We know that there has been a sidebar. The attorneys have approached the bench, so we are going to pull away from that a little bit. We know that Larry Nassar is here. He is in Eaton County. This is the victim impact hearing for his future sentencing. And we still have Bob Bianchi here with us. Bob, before we left, we were talking about the importance of the victim witness program and how the victim witness program actually helps individuals who are survivors or who are victims of certain excuse me. So we're going to go back into the courtroom because we're getting back live action in the courtroom. We don't want you to miss anything. Welcome back to the Law&Crime Network. What you just saw was the end of the day in the Larry Nassar matter. We were out in Eaton County with Judge Cunningham. Judge Cunningham provided the legal procedure that's going to happen in the future. She stated that on Monday at 9 a.m. they would begin with closing summation by the prosecution, then closing by the defense. If the defendant so chooses to make a statement, then he can, but that is up to the defendant to do so. That's up to Larry Nassar to do so. And then immediately after, she will provide the sentencing. So we can expect that on Monday we will hear exactly how long or how much additional time, excuse me, Larry Nassar will have to serve. We are still here with Bob Bianchi this afternoon. Thanks so much for sticking around with us. We know, you know, we just heard from Rachel Dollenhander, who started this whole thing, and you know, what an amazing statement that she gave. She's so articulate, and I think that it was just wonderful for her to be able to close everything out. But I still want to get back to your question. I mean, the question that I was asking you in regards to the victim witness program that you had and how important it is for the prosecutor's office to have that kind of a program, or a department, excuse me. Yeah, so in the last 30 years, most states and counties did not have a victim witness unit, but as law started to progress, they started to demand that prosecutors' offices pay more attention. I told you before, in fact, the first murder case I ever tried as a prosecutor, we weren't even in contact with the victim's family about plea bargaining or whatever. And I know that sounds like really crazy now, but that was just the culture. As we went forward, though, we realized, well, the victims obviously should have a major say. So a lot of victims' rights laws were passed, and the victims' crime unit was one of those things. So when I became the head prosecutor, I had a lot of moving pieces in that office. I had lawyers, a lawyer staff, I had a detective staff, I had a support staff, but we had the victim witness unit, and they were the unsung heroes of our office. These people were amazing, whether it would go out to give notifications from the very beginning that a loved one died under some very tragic circumstances, thinking of one in particular where a girl was beaten with a pipe and then dismembered, put in suitcases, and was about to be dumped into a river. I mean, it's really tough when the police go with a victim witness advocate from the very beginning to tell such a shocking story, and then to walk them through the entire criminal justice system, because 30 years later we realized we a lot of times traumatize and re-victimize people who weren't familiar with the process, and the process can seem, I go back in my mind to a death penalty case I was trying as a prosecutor, where, and again, before the victim witness unit was in place, but the family would always attend the court proceedings during the trial. And I remember the dad saying, you know, I can't take this anymore. Everything is about the defendant's rights, you know, not saying things because it may prejudice the case. And he was like very agitated. Well, now we have victim witness people where we explain as lawyers and detectives the nuts and bolts of the courtroom and the process. But really, in truth, at the end of the day, who do they resonate with most at the end of a case? It's the victim witness person, because they were serving their emotional needs. Whether or not those emotional needs may have been counseling, just a shoulder to cry on. Really, they were amazing. My staff was just, and in particular, I can't account for anybody else's. It was in their DNA. They loved helping people. They were a tremendous asset to us. And you know what? A calmer victim's family, a calmer, you know, witness that has to testify makes a prosecutor better able to do their job.
Absolutely, absolutely. I have to agree with you. The department, the victim witness department, is so crucial because as prosecutors, what our job is to do, it's to prosecute the case. It's to bring it before a jury. So at sometimes, although, you know, we, of course, we have to get to know the victim, we have to get to know the victim's family, because ultimately they will be witnesses on the stand. But you want somebody who, as you said, is going to be there to be a support system for this victim and for their family. So I think that that's wonderful that you know, we have these victim laws, and then we have these departments in the state's office, or in the prosecutor's offices, excuse me, because it's so important.
And hope we can keep that funding too, because as we continue to use the phrase "do more with less," I used to say when I would go to my funding people, which were the freeholders of my county, and saying you can stretch an elastic band so far before it snaps. I mean, I have staff that are taking files home, 10, 15 files, and working on them at night.
I remember those days.
You know, working on weekends, coming in. Sometimes if there was a homicide call and they were on call, they were out 36 straight hours. They never asked for another dime, whatever. And then the first thing when they started playing the do more with less thing was to cut the victim witness services of all things. And I thought that was a misguided point of view. Absolutely.
Okay, so Monday, let's say you're the defense attorney. And do you think that Larry Nassar is going to have a statement? Or do you think that he should make a statement?
Let me start with, I was trying to watch the body language of the defense attorney. And this is just Bob Bianchi's subjective viewpoint, having been in a courtroom and knowing things. If it wasn't for the fact that a chair was confining that defense lawyer, he couldn't have been any further away or emotionally distant from his client. It's just an observation I made. The look on his face, the whole thing. Now, a lot of people will say, if I could just take a little sidebar here for a second.
Go ahead.
A lot of people ask this question, and it's always fascinated me. I know you've gotten it. When I was a young assistant prosecutor, people would chide me and say, oh, all you guys want to do is prosecute innocent people and put them in jail, which, as you know, is the last thing that we'd like to do. Nothing for a prosecutor is better than releasing an innocent person that we have wrongly charged or we thought was guilty of something they weren't. Then I became a defense attorney. That was before I got appointed as the head prosecutor. And the very same people would come up to me and say, all you want to do is get guilty people off. You know, so there's this profound, it was and they would say it with great vigor and almost hatred in their voice. Listen, I learned a quick lesson when I first became a defense attorney after being an assistant prosecutor, and my dad, who's 86 years old and still practicing law, reinforced the message. I had a case where a kid looked as guilty as heck on paper in a shooting of a cop. Wow. I was assigned the case by the public defender's office, and I was eager to take it because I was my first defense cases, having come out as a prosecutor. Long and short, I won't bore you with all the details, but having done a little bit of investigation, something didn't make sense, and another thing didn't make sense. And when you put it all together, it turned out evidence was withheld from us. Wow. A videotape existed of the shooting that was never turned over.
What do we call that? Brady
material, right?
Right.
Exculpatory information. To this day, I don't know if I find that most prosecutorial misconduct is more malfeasance than purposeful feasance. I have encountered a couple of squirrely people, but for the most part, it's just not having done the right investigation. But the videotape showed that my client did not do it. He had spent 3 years in jail at that time, waiting for a trial. And when I went home and I talked to my father about it, he said, well, now maybe you learned a valuable lesson, that your job as a defense lawyer is not to be a prosecutor anymore. Because if you do, somewhere down the road, if you start judging, somewhere down the road, an innocent person on your watch is going to go to jail. Wow. So I learned a valuable lesson with that. I'm not sure if that is actually where we were.
No, it's fine. It's fine. I guess what... we were talking about, well, you started by talking about the, I guess, the body language, for your subjective view of the body language between the defense attorney and Larry Nassar. Now, we do know that the defense attorney, and this may have been the reason why, we were made aware in the last hearing that he and his family were receiving death threats. So let's talk a little bit about that. I mean, when you have such a high-profile case, we know that every defendant is entitled to a defense.
That's exactly, what, thank you for cueing me in. That's exactly where I wanted to go. If we abandon the idea that everybody's entitled to a defense, listen, as a prosecutor, that's half my career. I investigated cases that I believed that so-and-so was the person that did it, and it turned out to be somebody else. I mean, we make mistakes. We are fallible human beings. And in fact, a good prosecutor always respects a good adversary on the defense. That's the check and balance that we need to make sure. Do most prosecutors do things nefariously? No, but they do make mistakes. And a lot of times what a defense attorney's job isn't necessarily to say they didn't do it. It's to say they did it, but let me explain to you why. The mitigating circumstances, instead of hitting the fly with a sledgehammer, as we talked about before, and giving the maximum sentence, judge or prosecutor, we're asking for something a little bit more merciful, a little bit more compassionate, that gives deterrence, punishes the conduct, but doesn't go too far. So a job of a defense attorney most times is just really trying to bring out the mitigation information to explain the conduct, not necessarily to say the conduct did not occur. Here, he has admitted guilt, and he has pled guilty. He's accepted responsibility, at least with respect to that. And the defense attorney's job right now is to try to get the judge to give as less a sentence as is humanly possible. And they'll do that by presenting mitigating information. I'd like to see what it is. It's going to be hard to find out whether it's a psychiatric thing or not. I don't know. And boy, I mean, having your client get up there, I would recommend only if he was going to just mea culpa, and I am a horrible person and I've done horrible things, and geez, I'd almost, tell him that's it. I mean, I really don't know how
there really isn't much that you can say. It's probably best to, as you said, say nothing at all. Just take it and know that you have your sentence, and just take it and then serve your time, and then that's it.
And of course, your attorney can always say, my client has told me he wishes me to express my regret or whatever. But I have seen some defendants get up there and I think intend to say the right thing, and then by the time it all got done, it made the situation a lot worse.
A lot worse. Well, you brought up a great point, because you brought up the fact that at this point, it's just more so to bring in the mitigating factors, if any, or in certain cases in general. I do want to let our viewers know that the DeFreeze trial will commence again on Monday. We do know that the court is not in session, but this is the case in which Christopher Whitaker, who is the defendant, he has not not denied that he kidnapped, raped, and used several handheld tools against 14-year-old Aliana DeFries. But it's going back to what Bob said. It's at this point, we believe that the defense is just trying to mitigate the circumstances because this is a death penalty case. So I did want our viewers to know that the trial will commence again on Monday. You know what we'll do? We are going to throw to a clip. We're going to we're going to watch the clip of Katie Black, who is also a survivor in the Larry Nassar case. So we're going to take you to that clip right now. Welcome back to the Law and Crime Network. We were just watching a clip from Katie Black, who was a survivor in the Larry Nassar case, and we saw that obviously the testimony given was quite emotional. She had both her mother and her father with her. And Bob, while we were watching, I know that you made the comment, like, you can only imagine how, you know, a parent, or particularly the father in this case, must feel. I mean, even when she mentioned how her dad felt once he found out what happened, you saw the emotion displayed from his face and even from his mother's face. How does that go forth with I just don't know how parents can move on from this. So, like, as a prosecutor, did you have to deal with that at all, like dealing with the parents and how they in turn move forward when, I guess, the victim in a case is a child?
Yeah, so for many years as a prosecutor, I was in the homicide squad doing homicide work, which obviously is the worst of all things,
right.
And of course sex crimes as well.
Mm-hmm.
But it reminds me, we were, as you said, even before the young lady mentioned her dad.
Okay, Bob, I think we're having some technical difficulties. But before we go to a clip, what I do want to do is I want to let you all know about a GoFundMe that was actually started for Randall Margraves. It was organized by an individual. A GoFundMe page was started in the event that he may have needed some legal fees. So we thought that that was something important that we could let you all know about. We do know that Randall Margraves was the father who lunged at Larry Nassar during the hearing. So if you guys want to go check it out, there is a GoFundMe. You can see how much money is raised. I'm not going to talk about it on air, but we did think that it was something interesting that that you guys might want to look at. What we're going to do is we're actually going to show you that clip, show you the clip of Mr. Margraves and what happened. So take a look.